Hello everyone, this is CS Priyanka. Welcome to my class. Um, so I'm here with the next video, that is Essentials of Valid Contract under the chapter Indian Contract Act 1872. Hope you have done my first video, that is important definitions under Contract Act. So uh, let's get started. Today relating to the essentials of valid contract. That means whenever in contract, means this Indian Contract Act 1872 is guiding us how to enter into a contract, what are the things we should keep in mind while preparing the contract. Okay, so what we should not miss, what are the essentials we should not miss, so that if we miss those essentials we can say this contract will not become valid. So that's why to make a contract valid, it is very much important for us to remember the essentials whatever we are going to do in this video or in this class. Okay, so let us start with the first essential. That means whenever we will enter into a contract, whenever we are going to enter into a contract, we should remember that there should be a proper offer as well as proper acceptance. I hope I am expecting that you have done my first video, that is important definition. There itself I said, like, first definition is coming about offer. That means the person should offer first, then such offer must be accepted by other person, then we can fix it like this is seller, this is buyer. Then the promise is come. Okay, promise is coming, like both the person, one is offering, other is accepting. So in that cases both are promising each other that they will give something to each other. One will transfer property and other will transfer money in exchange. So whenever we will prepare the contract, we should remember first is there should be a proper offer letter, there should be a proper acceptance letter. Okay, and to make a valid contract there must be a lawful offer. Lawful means legal. What does this legal means? That means the offer must be in writing, or some recording should be there, or there I am advertising my offer through any brochure, or through any channels, or through in a newspaper. So obviously some evidence or some proof should be there, so we can say such offer is lawful. And obviously on the other hand, a lawful acceptance also must be there by the other party. That means the party or the person who is accepting my proposal, that person also should accept in writing that I am accepting your offer with referring to that number of offer, etc, etc. So I should means the offerer or the seller should accept the acceptance letter also, or she should record also the words of the other party. If you don't have any evidence that like who has accepted and who is offering, then we cannot say that this is offer is proper or this acceptance is proper. So you know, in law everything, we in court also only understand papers or legal documents. They also don't understand any verbal communications and all, because you can make a fake witness and all. So they want evidence. So in law or in corporate, for doing business, we need to maintain those papers and legal documents. So we have to keep in mind in contract, first essentials we have to keep in mind, like there should be a proper offer. That means some evidence you should have, it's a written or advertisement or newspaper cutting, etc. Or also the other party should accept the same in also in a same way, like by sending a letter or by sending email or by uh, in call, etc, etc. Second is second essentials is intention to create legal relationship. So as per Indian Contract Act, we say like both the party should have the intention to create legal relationship. Okay, if we all know, like in Indian Contract Act, minimum two party must be there. Minimum two parties required to form a contract. Okay, because I cannot enter into a contract with myself. I need one more party. Now the case is in Indian Contract Act, this is also one more important essential, that both the parties, one is seller, one is buyer, should have the intention to create legal relationship. Legal means documentation must be proper. Okay, if they don't have, if means they, if there is no such intention on their parties, okay, then we can say there is no contract. Both the parties should have intention to create legal relationship with each other. I can give you one example by telling one case that is it's a very important and popular case law, Balfour versus Balfour. Here it's a husband wife case. Okay, listen very carefully. Balfour versus Balfour is a husband wife case. Here, husband was uh, employed on a government job in Ceylon. Okay. Now, government got a job, and that is also government. Husband got a government job in Ceylon. Now, he thought before joining, he should go somewhere for a trip. So he went to England with his wife. Okay. Now, when the vacation is over, for health reason, the wife said to husband that he don't want to come with husband. He wants to stay some days more in England. Okay, and he asked husband that you go and join. Okay, I will stay some more days here and then I will return. Husband said okay, fine. In between, husband promised to his wife that during the that time that the wife is staying here in England, okay, separate, or is she is living apart from husband in England, husband will send some money, that is pound 30 per month, for her maintenance purpose. Got it? Now afterwards, what happened? Some differences arise between husband and wife. Okay, differences arise between husband and wife, and husband failed to pay this money whatever he promised verbally to wife, and wife filed a case against husband. Okay, now the court said, or it was held in the court, that there was no legal relationship, or there was no intention to create legal relationship between this husband and wife. That's why there is no document between them. Husband said that husband will send the maintenance amount of pound 30 to wife. Is there any evidence? Is there? No. Wife said no. So in that cases, we can say it's a husband-wife relationship. They don't have, in that time, they don't have such intention of creating any legal intention relationship. But court don't understand any other words other than legal things. Court dismiss the case. Court says, as there is no contract, there is no intention to create, the parties don't have to, they were not, they don't have any intention to create legal relationship. That's why this case is not valid. So the court dismissed the case. So this is a very popular case law, Balfour versus Balfour. So we have to remember that whenever we are entering into a contract, means always we are entering in with our stranger. So we don't trust that person. So whenever there is a trust factor between husband wife, means brother sister, father mother, father son, or mother son. So obviously our intention was not like that to create any legal intent, means relationship. So contract always happens between two strangers, and if there is no intention to create legal relationship, if there is no contract, we can say the contract is not valid. To make a valid contract, the both the parties should have to create, we should have that intention to create a legal relationship. Okay, so they should have a proper contract, they should have proper offer, acceptance, etc., etc. Third, you all know lawful consideration. Lawful means valid or legal, you can say. That means consideration means value, something in return. It must be in value or money. And I said like it should not be illegal or unlawful or black money. You should not use your black money to buy any property. Okay. So whatever money you will invest or you will use to buy your property, it should be lawful and valid. Consideration means something in return. For example, I can say you A promises to sell a house to B for rupees 10,000. So here what happened? Object is what he wants to sell house. House is legal. You can sell house. And consideration for rupees 10,000. That is also legal or valid. So both are lawful. If I say like A wants to sell uh, cocaine, which is a banned product, for rupees 1 lakh, then though the object is void or illegal, immediately the consideration will also become void or illegal. We cannot. This contract will become illegal or invalid. Okay. So here you can, house is not a illegal property. So house is legal and also the consideration is legal. In that cases, both are lawful. You have to keep in mind while preparing the contract that object and money or consideration both should be lawful or legal. Next is competent of parties. What do you mean by competent or competency? Means eligibility. Who are the parties are eligible to enter into a contract? Okay. They should be capable of entering into a contract. For example, I can tell you minors are not eligible to enter into a contract. Minors in contract is void. Got it? Then the question comes about the competency of parties who are eligible to enter into a contract. I can say the 18 years of age. Okay. The person should reach, at least he should attain 18 years of age. He should be sound mind. That means should not be mad, mentally sick, criminal mentality, okay, lunatic, etc. etc. So he should be the person of sound mind, means he is capable of taking any decision in a contract. Then only he is eligible to enter into a contract. And lastly, not disqualified from contracting by any law. So for example, like you are disqualified for contracting because one insolvent, if any person become insolvent, insolvent means unable to pay debt. So you are unable to pay debt, you don't in that cases you will become insolvent and you will become disqualified by contracting any type of law. Or for example, you have broke the prison. Okay, you are in jail and you broke the prison, so obviously you are wanted. In that cases also you cannot. If your background is not clear, if your history is not clear, that means you are in jail or you have done a murder, serial murder. Okay, so this type of thing, so you are completely rejected to do any type of work from the court itself, you will get the order. So in that cases you are disqualified to do any type of contract by law. Got it? So you should not be disqualified. Disqualified means you are not insolvent or unsound mind, or you can say you are not a criminal, or you are like you broke the prison and came out, you are disqualified. Got it? Or you can say like you have not you have violated the rules. Okay. So violated means same thing, like you have violated the rules, you have contravened the rules, so you should be punished. So in that time also you are not eligible to enter into any type of contract. So these are the eligibility of the parties for entering into a contract. Next important thing you have to keep in mind, next essentials, that is free consent. Basically I can tell you both the parties A and B, when they are entering into a contract, they should have a free consent. What do you mean by free consent? Like A is feel free to speak anything to B. If A is having any question, he can do to B. and B is also feel free to say anything to A. So they are means they are feel free to give their consent, not forcefully. No other person should force B to tell something to A, or other third party should not force B or this party to enter into a contract. So whatever will be done by these parties will be done as per their wish and desire. Okay, so they should give their free consent what they want. If B wants to quit from the contract, that is also his free consent. No other people should influence B to do so. That is known as free consent. So parties should have the free consent. Okay, then only we can say this contract is valid. If they are doing anything forcefully, then we cannot say that this contract is valid. So the parties must have agreed upon the same thing in the same sense, that both parties should think the same thing in a same sense. Means A is thinking something and B is thinking something else, that will create clash in future. So both should have a free consent whenever they are entering into a contract. No third party should force them to do anything, and they should have a, means they should think the same thing in a same sense. And same an agreement, in which agreement they will enter into, like agreement should be made by free consent of the parties. That means no third party should interfere into the matter, or forcefully they should not enter into an agreement. Okay, so whatever they will do, they should do it freely. Got it? Without anyone's influence, any other person's influence, or without anyone's interference. So next is uh, this is also a very important point you have to remember. First of all, free consent is one of the important essentials to make a contract valid. Got it? So both the parties should have uh, the free consent. Okay, no other or third party or outside influence should not be there. Now, one questions usually comes as per section 14. Actually, it says like consent is said to be free when it is not caused by. This question is very, very important for you people. Like maximum time this question comes, like when a consent is said to be a free. Okay, so this is very important in LLB also, for CMA Inter also, for CA student also. When consent is said to be free, actually as per section 14 of Indian Contract Act, okay, consent is said to be free when it is not caused by these following. I will explain you one by one. Whenever you are, for example, think you entered, or A is entering into a contract with B. Now in this contract, whenever you are making this contract, you have to remember these essentials should be there in this contract to make this contract valid. Now the thing is, whenever they will enter into this contract, their consent should be free enough. Now when we can say like their consent is free, when in their consent these points won't be there, will not be there. Okay, so what are those? First of all, coercion. These are all new words you will learn here. So what do you mean by the term coercion? Coercion means, for example, you say like A and B, someone, for example C, is threatening to B that if you don't enter into this contract, I will see you. So by getting this threat, means on the base of these threats or repeated blackmailing, okay, so C is blackmailing B that if you don't enter into this contract with A, then I will see you, or I will see your family, like this type of threat B is getting repeatedly from C. Now out of fear, B is entering into the contract with A. So if any act, or if you are entering into a contract by force or by threats of some other party, that is actually legally we called it, it's a caused by coercion. So whatever consent you are giving, if you are giving your consent on by threats or by getting threats, or someone is continuously forcing you to do such act, such is known as coercion, and coercion is coming under section 15. So I have made this slide like that so that it will be easier for you to remember. So section 14 of Indian contract is telling you like consent is said to be free when it is not caused by these following fact. Under that, first is coercion. Coercion means the catchword is threats or force. Whenever you are forcefully or by getting by someone is threatening you to do something, and your action or your conduct, okay, that time we called it like it is caused by coercion. We can say your, this is not your consent, someone is forcing you to do this, so that should not be there in your free consent. Next is undue influence, that is coming under section 16. That means no other person should indue, means should influence you to do anything or to give your consent. You are giving your consent uh, and means under influence of some other party. Got it? So it is written like it is an equitable doctrine that involves one person taking an advantage of a position of power over another person. This is equality in power between the parties can spoil one party's consent as they are unable to freely exercise their independent will. So basically though you can get it like some other third party interference is there, or third party is continuously influencing you to do such act. It's not your will. You are not doing it of your own. Now for example I can tell you like some MLA or some MLA or secretary in your locality. Okay, they are simply uh, taking their advantages of their position. For example, like MLA. So you wants to construct a building in your area, and the MLA or any other powerful person in your area is telling you like if you want to construct your house in this area, then you have to pay me some money. Okay, so these means that you, out of fear, that means you have to stay in his area, that's why you have to pay some money, but that is illegal. Okay, that is illegal in nature. So that means you want to stay peacefully in that area, that's why you will pay to MLA. Got it? But if you think like this MLA is taking the advantages of his position and simply influencing, undue influence, like simply influencing you to do such work, okay, so that is also should not be there in your consent. So unnecessary outside influence or third party influence, undue influence should not be there in your consent, whatever you will give in the time of entering into a contract with the other party. Next is obviously you should not involve with any fraud. Okay, any type of fraud you should not do in your free consent. For example, you are giving your consent freely for doing some fraud, that is coming under section 17. That is also we called it like if your consent is caused by fraud, that is also we cannot say your consent is free. When we can say like your consent is not free, for example, whatever fact you are telling is not true, it's a false fact you are simply telling. While telling something, you are simply concealing some fact. Concealing means hiding. Okay, so for example you don't have all the papers of your property, for means whenever you are entering into a contract or something, but you are simply hiding. Okay, so you are just concealing the main fact from the other person. That is also a type of fraud. You are telling everything is okay, but actually you are having some disputes in your property or papers. Okay, so you are hiding any important fact which you should inform to other people, inform to your party. So whenever you want to do something with the objective of or with the intention of committing any fraud, that is also that is known as any other act fitted to deceive. That means whenever you wants to do something but your intention is not right, your intention is negative, your main intention is to commit some fraud. Okay, so that's why you are telling something for committing any fraud. That is also your consent is not free. And any such act or omission as law specially declares to be fraudulent. That means whatever is not there in law or act, you are committing that work. That means you are not following law, or you are contravening the rules and regulation, or you are violating the rules. In that cases also we can say that you are doing fraud. Next is section 18, misrepresentation. So what does this misrepresentation means? That means you are misguiding someone. Okay, simply you are misguiding someone. So whatever you are representing, okay, your representation, when you are giving your or whenever your representation is wrongly made, either innocently or intentionally, is known as misrepresentation. That means what, some statement or fact you are telling, okay, some statement or fact you are telling, there can be two way. Okay, first is without knowing the actual fact, you are telling a wrong statement. That is, we can say you are telling this wrong statement or fact innocently. This is also known as misrepresentation. On the other hand, intentionally, okay, intentionally to misguiding someone, you are telling some wrong fact. That is also, we called it misrepresentation, as well as that is also known as fraud. Okay, both. So misrepresentation can be of two types. First of all, what you are telling some statement which is not true, that is known as unwarranted statement. So some statement you are telling or giving which is actually the fact is not correct or true, that is unwarranted statement. That also known as you are misrepresenting someone or you are misguiding someone. And other misrepresentation is breach of duty. That means whatever your duty is, you are simply violating. Okay, so you are not following your duty, you are not following the rules and regulation, and you are simply ignoring while doing duty. You are simply ignoring your duties and rights. That is known as breach of duty. Breach means not following. So whatever your do's and don'ts, you are not following your do's. So I have written like unwarranted statement is a statement made by a person which is not true, and breach of duty means violation or omission of legal or moral duty. That means whatever you are supposed to do, you are not doing that act. That is breach of duty. Both are coming under misrepresentation. So I can tell you, like for example, like you are standing in the road and I am searching for some address. I'm asking you, where is this address? You are just simply telling me maybe this here left. So actually without knowing it, you are telling me, and innocently you have told me, or you have you are misguiding me, or you have misguided me. So that is also, we called it misrepresentation. Next is, for example, I'm asking you some address, you knew it, still intentionally you are just for harassing me, you are just telling me some wrong statement. That is also some kind of misrepresentation. But though you have done intentionally na, along with misrepresentation, we can also call it as a fraud. So there should not be such thing in your consent, then your consent will not be free. Next come to mistake, which is coming under section 20, 21 and 22. There can be two types of mistake, okay, as per law. First of all, mistake of law, and next is mistake of fact. What is law? Law means act, rules, regulation, provision, articles. Okay, so whatever act, rules, regulation, provisions we used to read in these law or these chapters act, these are all means, it is not, it is obvious that maximum people don't even know the provisions, rules and regulation. We professionals, we knew it, but maximum people don't even know. That's why they hire lawyers and all professionals. So if you don't know the law and still you are doing such act without knowing the law, we called it as mistake of law. Okay. On the other hand, fact. You don't know about the fact. For example, I can tell you A entered into a contract with B for selling one property. Got it? Property belongs to A. So A is seller, B is buyer. Now, for example, think A and B entered into a contract without knowing the law. So obviously they will do the mistake while preparing the contract. That means they don't know the proper provisions, how they will prepare, essentials, all these matters. So if they do any type of if they miss any essentials from the contract, then we can say they have done the mistake of law. That means without knowing the proper rules and regulation, they entered into a contract. But what is about fact? For example, this property. Okay. For example, think this one he is A wants to sell one flat to B, and that flat, for example, 1200 square feet. Okay, actual price. Okay, actual documents of this paper. Okay, every details. Mistake of fact means A wants to sell his property or flat, whatever it is, but he is not aware of the actual fact of the or particulars of the property. Simply he has written 1100 square feet and all. Actual things he is not aware. So if they do any type of mistakes relating to this fact of the property or asset, we can say mistake of fact. So law is relating to act, rules, provisions. That means without knowing the law act, if you enter into a contract and if you do any mistake, we can say mistake of law. And fact means without knowing the details, particulars about the plot, property, if you do any type of mistakes, we can say it's a mistake of fact. Now come under the mistake of law. Mistake of law of the country. That means in which country you are staying, you should know the law of that country. If you do the mistake, if you don't know the law of your country, we can say it's a mistake of law. Or else if you enter into a contract with any foreigner or the party who is belongs to the out of India, then obviously if you don't know their law or if you are not aware their law, okay, if you are entering into any type of transaction with their country and all, then it's a mistake of law of foreign country. Okay. Mistake of law can be of two types. One is bilateral mistake, one is unilateral. Bi means, what do you mean by bi? It's a two. That means both the parties are not aware of the fact. We called it bilateral mistake. Uni means only one party. Okay. Out of two party, one party is not aware of the fact. So in case of unilateral mistake, we actually says like if one party is not aware, other party, the party who knows the fact, he should educate the other about the fact. So there can be of two types of mistake. One is bi, that both the parties are not aware of the fact, and on the other hand unilateral, where only one is not aware, other is aware and he is silent. Okay. So thank you. These are the essentials we have read under the Indian Contract Act. So hope it is clear to you. Still, if you are having any problem, you can write in the comment section. Obviously, I will come back to you. So if you like it, please don't forget to hit the like, subscribe, and share with your friends. Thank you. And soon the next topic I will bring under this chapter. So see you soon. Bye.